everyone. Thank you for joining us today for Constangy's webinar, Clocking In on Wage and Hour Compliance Strategies for 2026. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat. You can access the chat function through the toolbar located at the bottom of your screen. Our presenters may not be able to address all of your questions during this session, but we encourage you to reach out following the presentation. Their contact information will be included in our post-webinar follow-up email. This program is approved for SHRM and HRCI credits. We'll be sharing those codes at the end of this presentation, so please stick around in order to get them. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm now going to turn it over to today's presenters, Jason Friedman and Rachael Rustmann.
Great. Thanks, Christine. And thank you all for joining us. My name is Jason Friedman. I'm a partner in our DC Metro office. I've been practicing for 14 years. I got my start on the plaintiff side at first, and I've been at Constangy for 8 years now. Most of my practice focuses on wage and hour issues that we're going to talk about today, both representing clients with advice in compliance, attempting to avoid litigation, right? That's always better to avoid it at the front end. But unfortunately, we also do a lot of litigation as well. And the clients we represent, myself and Rachael, range from Fortune 500 clients to local businesses that are relatively small. So hopefully the advice we give today is going to apply to everyone. So you'll be hearing from me and then also my associate, Rachael.
Hi, everyone. I'm Rachael Rustmann. I'm an associate attorney with the Nashville office, although I like to make sure everybody knows I am originally from Texas. I have been practicing law for 13 years. The first 9 years of my employment was exclusively FLSA on the plaintiff side. And everybody jokes that when you go to defense, you join the dark side, but I like to think that we are on the light side here. And so, yeah, I've been with Constangy for 4 years. In addition to litigation and compliance, we also do a lot more arbitration work now. We are seeing that more and more with employers rolling out arbitration agreements.
So what are we talking about today? Well, we're talking about wage and hour compliance and issues to avoid, some trends that we've been seeing in 2026. Today's presentation is going to focus mostly on federal law, which is the Fair Labor Standards Act, the FLSA. If you hear us say the FLSA, that's what we mean, the Fair Labor Standards Act. There are state laws, a lot of state wage and hour laws. We'll touch on some, but the majority of the presentation will be about federal law. Obviously, the state laws will go above and beyond what is required by the federal law. So be sure that you are compliant with state law as well. So why are we talking about wage and hour compliance? Well, just last year in 2025, there were over 5,700 new cases filed in federal court alleging FLSA claims. That does not count state law claims, state court claims. And so clearly this is prevalent. It's very lucrative for plaintiffs' attorneys, and so it's something that we want our clients to be aware of and to avoid these common mistakes and pitfalls. Under the FLSA, small mistakes can create significant liability. I always tell clients no good deed goes unpunished. Something as simple as giving an employee a bonus, right, out of the goodness of your heart or because they did such a great job, that can actually create liability, unfortunately. So again, there are a lot of pitfalls. We're going to go over them. So the consequences of an FLSA violation, just to drive the point home, not only can someone be entitled to back wages, which take the form of minimum wage or overtime, they're usually entitled to liquidated damages, which is a doubling of damages, 2x. And then the really scary part is that the FLSA, like most employment laws, is a fee-shifting statute. That's why there are a lot of plaintiffs' attorneys out there bringing FLSA claims. And there does not need to be any relation between the amount recovered for the employee and the amount recovered by the plaintiff's attorney. In my past life as a plaintiff's attorney, I had a case where we recovered $10,000 for the client, and my firm recovered $100,000 in attorney's fees. And that is way more common than you might think. So it's important to sort of wrap your head around compliance with the FLSA to avoid situations like that as well. The FLSA also allows for group litigation. There's a collective action mechanism That also gets really scary when you deal with a workforce of hundreds or sometimes thousands of individuals that can all bring the same claim. And then finally, the government also does enforce the FLSA. I've been helping a client actually this week with a DOL, Department of Labor investigation, and there are civil money penalties that can come along with that. So there's a lot of ways to get tripped up, and we're going to do our best today to make sure that you guys are in good shape.
So, like Jason said, with the attorney fee provision and that, it can be a lot more common than you think. I too, when I was on the plaintiff side, had a case once that actually went all the way to trial and plaintiff recovered, I believe it was like $838. And so under $1,000, and we filed a fee petition with the court requesting over $90,000 in attorney's fees. So, like we said, it's more common than you think that the attorney's fees can significantly outweigh the actual recovery to the employee. But just to kind of get into a high level overview of what we're going to be discussing today, we wanted to talk about some of the biggest risks that employers face in 2026. Even though wage and hour laws have been around for decades, the FLSA was enacted in, I think, 1938. The same core issues continue to drive claims, investigations, and lawsuits year after year. The difference today is that remote work, technology, and, as we said, an increasingly complex patchwork of state laws has made these issues more difficult for companies to manage. The first risk area that companies face is employee misclassification. We'll talk about that more later. But sometimes, employers will classify their employees as exempt from overtime without fully analyzing whether an exemption applies, or they'll classify them as exempt and then 10 years down the road, the employee is still exempt and they haven't revisited that classification to see if the job duties have changed. With employee misclassification can then come overtime violations. We also see a lot of off the clock work cases. This can include employees performing work before a shift starts, after a shift ends, during meal breaks. Again, we'll talk about this more later, or responding to emails and messages outside of normal working hours. While those situations are often unintentional, they can create liability if the employer knows or should have known that the employee was performing the work. Just kind of simple payroll errors can continue to be a major source of wage and hour exposure. Mistakes involving bonuses, commissions, meal break deductions, travel time, or overtime calculations can affect large groups of employees and quickly become expensive, again, as we talked about in the potential collective action realm. And lastly, remote work has added a new layer of complexity to all of these issues for employers. Employees, as I keep referencing my cell phone throughout, employees can work from virtually anywhere in the world because of these little bricks that follow us around everywhere and at any time, which makes tracking compensable work time much more difficult than it was in a traditional workplace setting. And so as we move through today's presentation, we're just going to kind of focus on these issues that are, continually popping up and just kind of strategies employers can use to identify these issues early, strengthen their compliance efforts, and just reduce the likelihood that these common problems can turn into a really costly claim.
So we'll start with the basics. What is the FLSA and what do you need to know? So the FLSA, Fair Labor Standards Act, covers all employers who have over $500,000 in yearly revenue. It actually covers more than that. There's other ways that the FLSA can cover you and your employees. I think it's pretty safe to assume if you have in-house HR or in-house attorneys, if you are on this call, it is very, very likely that your company and your employees are covered by the FLSA. And so what does the FLSA do? It ensures two things: minimum wage and overtime. So the federal minimum wage is $7.25 an hour, and it ensures that employees receive overtime at 1.5 times or 1.5x their regular rate for hours worked over 40 in a week. And I say regular rate, that's actually a term of art. We'll talk about that in a little bit, but it's if you hire someone at $10 an hour, it is not a given that their overtime rate will be $15 an hour. So that's something we see a lot of companies get tripped up on. We'll cover regular rate later in the presentation. So that's what the FLSA does, ensures minimum wage and overtime. It's important to note the default is that an employee is entitled to overtime. It's not something that you can contract out of. It's not something that you can create two different companies and split the hours. I see companies try to do this where It's clearly the same enterprise, but they pay from multiple sources, and they say, oh, therefore they didn't work any overtime. Of course, don't look favorably on that. So again, the default is that the employee is entitled to overtime. There are exceptions to this rule, however, and we'll talk about these today. Some of the major ones um, are the white collar exemptions. Like I said, we'll get to those later. Those have to do with the duties that an employee performs. I should say there are three requirements, right? The most important of which is the duties that an employee performs. And we'll talk about those. The other two are pretty easy to satisfy, but it's important to just check and make sure that if you are classifying someone as exempt, you're also doing these two. Someone has to be paid on a salary basis and paid a salary level or the proper salary level, which is currently set at $684 a week or $35,568 a year. If you're not paid on a salary basis, you're not paid at that proper salary level. Doesn't really matter what your duties are. You're not going to fall into one of the major exemptions. Also, if you have a highly paid workforce, you can rely on what's called the highly compensated exemption. If an individual is making over $107,432 a year, the duties requirements are a little less strict, obviously because the more you're being paid, the more likely it is you're doing exempt level work. So that's the quick FLSA background, and now we can dive in.
So some of the mistakes we see most often, one thing we've learned from working with employers over the years in both litigation and compliance investigation is that, as Jason said earlier, no good deed goes unpunished. Many wage and hour claims, they don't arise because employers intentionally fail to pay their employees correctly. More often than not, they just start with relatively ordinary timekeeping issues that weren't identified or addressed early enough. We said maybe an employee clocks in early or forgets to gets to work and forgets to clock in, or they start their work early before clocking in. They log into a system. Sometimes you have to log into a VPN and then a phone system and all these things. And doing all that collectively may take you 5-10 minutes. If an employee logs into those systems before clocking in, they may mistakenly be performing work off the clock. Individually, these things seem minor, but over time they can create exposure. And as we talked about with the collective action mechanism, it can be potentially significant exposure. Meal periods, they can create issues too. While automatic meal deductions are common and technically legal, as Jason will discuss later, we don't recommend employers use them. If they do, however, employers need a way for employees to report when they've worked through lunch or don't get a full meal break. This is particularly important for employers with operations in states like California, Illinois, Colorado, or Massachusetts, where meal period requirements can be more detailed than what is required under the FLSA, and some of them even carry additional penalties for non-compliance. It's important to remember the FLSA does not require employers to provide a meal break. However, if an employer provides an unpaid meal period, the employee generally must be completely relieved from duty for that time to remain unpaid. If the employee performs work during their meal period, that time needs to be compensated. And again, like I said, if you have an employee who clocks out and goes somewhere to take their lunch, but they bring their cell phone with them and they get a phone call, well, if it's work related, that may create some litigation risk. The best practice is just to make sure that employees know how to report missed or interrupted meal periods and to train managers not to discourage that type of reporting. Some of our clients address this by requiring employees to certify at the end of the day or pay period that they received all their meal periods or they accurately reported any missed or interrupted breaks. Others use an exception reporting process that allows them to submit a missed meal form electronically, either through the timekeeping system or just like an old school written form. There really isn't a one size fits all solution. The important thing is just making sure employees have a simple, realistic way to inform the company when an automatic deduction should not have occurred. Again, it's not something we recommend our clients do, but it is technically legal. We also see situations where employees just simply aren't recording all of their time. Sometimes they forget, sometimes, again, they're working remotely, or they just don't think a few minutes here and there really matter. Another common issue is unauthorized overtime. Employers can absolutely require employees to obtain approval before an employee works overtime. But if the work is actually performed, even without approval, it generally still has to be paid. If an employee stays late to finish a project, answer emails after hours, or comes in early to prepare without obtaining approval, if the employer knows or should have known that the work was being performed, it has to be paid. The better approach, though, is pay for that time and address any violation of the overtime approval policy separately through coaching or discipline if appropriate. Finally, consistency matters. One manager may strictly follow the rules while another either just kind of allows it, or unfortunately, sometimes there are rogue managers who encourage it. If a manager's metrics at the company is tied to their subordinates' hours and overtime worked, that's generally where we kind of start to see the problems starting. But the bottom line really is just that good policies are important, but they're really only effective if employees understand them and managers actually follow them and apply them consistently.
Yeah, and just to underline one of the points Rachel made, that you can have the best policies in the world. You probably already do, especially if we wrote them for you at Constangy, or we'd be happy to write great policies for you. But the best policies in the world don't matter if your management team does not enforce them effectively. And a big blind spot we see with a lot of clients is a lack of manager training on what those policies are and how to implement those policies. So, yeah, that was a good list by Rachel. But the one thing to keep in mind with all that going forward is the managers are really the front line of enforcing those policies. So just assuming that they know how to do that can get you in trouble. So manager training can help fix a lot of those issues. Um, so Rachel touched on this briefly, but can employers prohibit overtime? The answer is yes. Um, I guess I should take a step back. Why are we even talking about overtime? Well, overtime's expensive, right? Employers try to avoid it as they should because it's very expensive. How do we calculate overtime? Well, we take the regular rate for non-exempt employees. We take the regular rate per hour for every hour up to 40, and then time and a half or 1.5x the regular rate for all hours of work over 40 in each week. So what's the regular rate? Well, the regular rate is calculated by the total pay for the week, which includes their hourly rate, any non-discretionary bonuses, commissions, shift differentials, what their total pay or the total remuneration for that week, and divided by the total number of hours. That's how you get your regular rate. And then for every hour worked over 40, there's a 0.5x premium, a halftime premium, times the regular rate, times the overtime hours worked. So again, it gets expensive. I totally understand why employers have an incentive to not pay overtime. And as Rachel said, policies of not allowing overtime or requiring prior approval for overtime, we recommend them. They're used by many of our clients. They're used by many employers. It does not mean that you don't pay for overtime that is actually worked, though, right? That's important. Rachel touched on that. You don't pay someone just for their scheduled hours or just for their pre-approved hours. You pay someone for the hours they actually work. It can absolutely be a violation of policy to work overtime that's not approved, or any overtime, right? And you can write that person up, that employee up. You can discipline that person. If you have a well-crafted overtime policy, that should also lay out what the potential discipline is, sometimes up to and including termination. And that's all well and good, but as Rachel said, you still have to pay that individual for the hours they actually worked. And that's something we see a lot of employers get tripped up on. So it's a point worth underlining.
So I find this case very interesting. It's a recent case out of the Fifth Circuit, which tends to be a more employer-friendly jurisdiction. The Fifth Circuit includes Texas, Louisiana, and Mississippi. It provides a helpful reminder about a fundamental principle under the FLSA. We've said multiple times already throughout this that it's if the company knew or should have known that the overtime was worked, it has to be paid. So Merritt versus Texas Farm Bureau touches on this. In this case, Merritt worked as an agency manager overseeing insurance agents across multiple locations. The company classified him as an independent contractor, didn't require him to track his hours, paid him entirely on commission, He worked without daily supervision, and the company allowed him to set his own schedule because they viewed him as an independent contractor. The lower court record showed that during his time there, annually, he earned between $555,000 and $625,000. He later challenged this classification and sued the company for unpaid overtime under the FLSA. The lower court found that he had been misclassified. He should have been treated as an employee entitled to overtime protections. Again, making over $500,000 a year. The court further found that he had worked about 800 plus hours of overtime that he should have been paid. But the jury had to decide whether or not the company knew or should have known about the overtime he worked. So what makes this case kind of interesting for employers. Again, he won the classification argument or misclassification argument. The employer lost on that issue. But the jury ultimately found that the company did not have actual or constructive knowledge of the alleged overtime, and the Fifth Circuit affirmed. Now, again, I want to reiterate the facts of this case because it's kind of a perfect storm. It's a very unique set of facts. Again, the company didn't require him to track his hours. He was paid on a commission, so his payment wasn't even tied to hours he made up. I know a lot of companies or the paycheck will show 80 hours per 2 weeks when somebody's salaried. He worked without daily supervision and he set his own schedule. So it kind of makes sense in this case why the company was not aware of the hours worked. But again, this one is a truly perfect storm where the company did not have knowledge of his overtime worked. As a result, despite prevailing on the misclassification issue, Merritt didn't recover any overtime damages because he couldn't establish the employer knowledge element of his FLSA claim. That said, employers cannot ignore obvious signs that employees are working off the clock. If a manager knows that their employee is scheduled to work 9 to 5, 9 to 6, and they start getting emails from their employees regularly at 7, 8, 9 o'clock, and they see that they're not clocked in, or they see that the employee has done work outside of their shift, or just kind of otherwise observed any work activity, those facts may support a finding that the company had constructive knowledge, and then the company would be on the hook. And again, here, this guy was making $500,000 a year. And had the company been aware, they would have had to pay him more.
Yeah, just to piggyback on that, if an employee or if an individual is working, yeah, if an employee is doing the volume of work that couldn't even be done in 40 hours as well, right? So if somehow you become so productive, you're doing the work of two people, that can even be enough for an employer to be on notice of they must be working off the clock. They must be doing something else because we've already timed it out that every widget made takes an hour, and instead of giving me 40 widgets, you've given me 80 widgets. Well, the company should know at that point. So it's definitely a nice case for employers. It's a case that, it's an argument that we make now in litigation based on this case, but um, the burying your head in the sand defense, that's not going to end up working um, as far as hours here. So we've been throwing around the words exempt and non-exempt a little bit. We'll give some background here, right? Why is it important whether someone's exempt or not exempt? Well, obviously, if someone is exempt from the FLSA's overtime requirements, there's no issue with paying overtime. There's no issue with how many hours are they working because their salary is intended to cover any and all hours worked. However, if someone is not properly classified as exempt, right? If an employer classifies someone as exempt and someone challenges that and wins, there's potential for big liability because there can likely be a decent amount of overtime hours, right? Employers don't think they have to pay an exempt employee overtime, and so they don't put a cap on their hours. They don't say don't work overtime. They say, sure, you work 60, 70 hours, why not, right? And depending on the court, the amount of wages that can be recovered are either that overtime premium I talked about before, the 0.5 of the regular rate, or some courts will say that your salary was only intended to cover you for 40 hours in a week, and that all the overtime hours are recovered at 1.5, the full 1.5 of your regular rate for every overtime hour work. So on a per plaintiff basis, a per claimant basis, misclassification tends to be the most, the largest amount of liability. So we can go through the general the general, I guess the three main exemptions to know that most employers rely on. They're known as the white collar exemptions. It's the executive exemption, the learned professional exemption, and the administrative exemption. So again, um, as I talked about before, all three exemptions require payment at the proper salary level or higher, and all require payment on a salary basis. I should briefly talk about, I guess, that salary basis does not allow for partial day deductions, right? You have your guaranteed salary regardless of the amount of work that someone is doing. So once you start deducting from salary because they only worked 36 hours, they didn't work 40 hours this week, or oh, they didn't produce enough widgets, I'm going to deduct their salary, right? Then that becomes an issue. Um, so so what we're going to talk about then is the executive exemption, the learned professional exemption, and the administrative exemption, and the duties required for that. Rachel is going to actually talk about duties versus job descriptions and job titles, but again, these are the duties for these exemptions, the duties requirements. So for the executive exemption, it's also known as the managerial exemption, that your primary duty has to be managing, and you have to regularly direct the work of two or more employees at a time, full-time employees. Or another way of putting that is 80 hours worth of employee work. In a work week, you have to be managing and directing. So what are some potential pitfalls here? I see this more often than I'd like is sometimes someone is not managing employees and they're actually managing independent contractors, right? Managing an independent contractor does not help satisfy the executive exemption duty. Um, the other main pitfall we see, and this happens a lot with assistant managers or working foremen, was the management actually the primary duty? And there's a lot of case law cutting both ways. There are some cases out there that say, look, if you are the highest level manager in your location, you're setting schedules, you're hiring and firing, you're disciplining, you're setting rates of pay, but you spend 90% of your time stocking shelves, that's okay because the most important part of your duty, your primary duty, is that management duty, right? On the flip side of that, you could be an assistant manager and you have seven other assistant managers and three other general managers, and you really are just stocking shelves, and your opinion is not given a lot of weight when it comes to hiring or discipline or anything like that. And in that situation, it's very likely that you are not going to be found to be an exempt employee, and that you are entitled to overtime. So again, the executive exemption, pretty easy to comply with as long as you're actually managing and you're managing the right number of full-time employees. It's one that I like to try to have clients rely on because it's one that's relatively easy to defend. The learned professional exemption is actually usually even easier to defend. We don't see a lot of litigation on this one, but this is where your primary duty requires advanced knowledge acquired by a prolonged course of study. This is, for example, doctors and lawyers are pretty clear cut that they are learned professionals and fall under that exemption. There can be some issues here. Sometimes like accountants can sort of cut both ways, or anyone in a financial sort of job, if you have an in-house accountant or in-house payroll people. Sometimes if a CPA is required, let's say, well, courts have found that a lot of times that CPA can be that prolonged course of study. And Rachel will touch on this a little bit more too, but the important distinction here is just because someone has a CPA doesn't mean they're actually performing CPA level duties. So if the job description or the job posting for that hiring didn't require it and someone happens to have it, that it's unlikely that you're going to be able to rely on that exemption. And then the last exemption of those main three, the white collar exemptions, is the administrative exemption. This is one where your primary duty has to be office or non-manual work that is directly related to the management or general business operations and requires the exercise of discretion and independent judgment. And if you know exactly what that means, you probably don't need to be on this webinar. You can probably be teaching it because no one knows exactly what that means, right? There's litigation all over the place. Courts are very widely in what that means. And there are a lot of litigation here. Generally speaking, HR managers, higher level people in the marketing department, is really what the administrative exemption was meant to cover. A good rule of thumb that I give clients is that the further down a food chain someone is, the harder it is to rely on this exemption. But I will say, well, if only because how much of your own independent judgment and discretion are you using if you are the lowest person on the food chain, right? I'll say that I usually advise clients not to rely on this unless they really have to. Ideally, you can find someone who also happens to manage two people, and then you can rely on both exemptions. Um, but yeah, so those are the three main exemptions, things to be thinking about as far as how you classify your employees. And Rachel mentioned it earlier, but obviously as companies grow and change, classifications of exempt or non-exempt individuals should be reviewed. It's another thing too to think about, do we actually need to risk it, right? The first thing I talk to clients about when they say, "Oh, I really want this person to be exempt," and I say, "Do they work more than 40 hours a week?" They say, "No, no, they only work about 37 hours a week." Well, then it doesn't really matter, right? There's no liability, practically speaking, because if someone doesn't work overtime and they're getting more than minimum wage, there's no FLSA violation. So there's a lot to think about when you're thinking about classifying employees. Um, so yeah, we'll go to the next slide here for Rachel.
So yeah, so when companies are kind of looking at whether or not employees should be classified as exempt versus non-exempt, the most important thing they need to focus on is the employee's job duties. Um, it doesn't matter what the job title says. I can't tell you how many times we've had cases on both the plaintiff and defense side where an employee's job title is manager. And come to find out, they didn't manage anything. I had a case once where there was a marketing manager who was classified as exempt, but when we got down to it, he was just mostly posting on social media for the company, updating spreadsheets, implementing various, campaigns designed and approved by senior leadership above him. He didn't have the authority to hire, fire, he didn't supervise anybody. He didn't make any decisions without running it past somebody else. But they gave him the title marketing manager. I'm sure it looked great on his LinkedIn, but at the end of the day, it didn't make him an exempt employee. So some of the questions employers should ask is what work is the employee actually performing on a day-to-day basis? How much, as that wonderful phrase Jason used, discretion and independent judgment did the employee actually exercise? If they are running everything past their boss, they are not exercising discretion and independent judgment. If they have a checklist of stuff they have to go through every time, there's no discretion in that. And does the employee actually supervise other employees? The most important thing, though, is like we said, the actual work needs to align with the written job description. We see a lot of times where either the company has rolled out a job description. In reality, the job has changed. The company has changed. I mean, companies grow, they shrink, they merge with other companies. And all of a sudden it can be 3, 4, 5 years down the road and nobody's looked at the job description because they've just always filled that role. And it no longer matches the actual day-to-day duties of what the employee is doing. And unfortunately, that can come back to bite the company in the butt. I mean, one of the most common mistakes we see is employers relying on outdated job descriptions that just no longer reflect reality.
So yeah, just to piggyback on that, the idea, and again, this is only because it's something we see all the time, is when companies change and job descriptions or jobs themselves change, you might have managed 10 people at once, and then all of a sudden you get restructured and now you're managing one person. Your job didn't change at all, but you only have one person under you. Well, unless that one person is working 80 hours, you're not going to end up supervising 80 hours, 80 employee hours, and that managerial or executive exemption is not going to apply. So again, as companies change, it's important to keep up with job descriptions and reevaluating exemptions. So, all right. Well, we see a lot of issues with independent contractors as well, so we wanted to touch on that. Um, Obviously, why does this matter? Well, independent contractors are a lot cheaper than employees, right? They don't have the same protections that employers are required to give employees. And so a lot of companies are outsourcing tasks, right? I mean, it makes financial sense. Um, but it comes with some potential pitfalls that we're going to talk about. So while the test for independent contractors keeps getting tweaked by the Department of Labor, depending on what party's in office, and different states have weighed in with their own tests. Generally speaking, you look at who controls the work. Does the work operate, or does the worker operate their own business, and how integrated is that work or the worker into the business? So I like to talk about sort of a spectrum of workers, right? On the one end, you have the quintessential independent contractor, you have a plumber, right? If unless you are a plumbing company, right? You hire a plumber, they're fixing a toilet, the plumber has got his own equipment, the plumber takes his own, has his own transportation, sets his own price, decides how he's going to fix your toilet, comes in for an hour, fixes it, 5 hours, who knows, what happened to your toilet, but takes as long as they want, gives you a price, and then they leave. They have 1,000 other companies or 10 other companies that they go fix toilets for, right? Quintessential independent contractor. On the other end of the spectrum, you have individuals that are clearly employees. They don't work for anyone else. They report directly to a manager. That manager tells them exactly how to do their work, what work to do, gives them tasks, sets their rate and method of pay, all these other things. So within that spectrum, um, there is where the litigation sort of creeps up. I had a case recently where a company outsourced one part of their job or one part of their product. They assumed that this independent contractor had their own business, right? They had an LLC. They assumed that they were doing this for a lot of other different companies. The company made a couple sort of key mistakes. One of which was they listed this independent contractor as a team member at one of their annual meetings. They also didn't realize this person was not working for anyone else, right? And this person really didn't decide how to do that task. And so calling someone an independent contractor is not going to be the end all be all. And courts are going to make you go through and prove why is this person an independent contractor or should they be classified as an employee? This is also where state laws can get a little tricky. So this case happened to be in Virginia. Virginia had recently passed a law that said the burden is actually on the employer, right? The default is if you did work for a company, you're an employee unless the employer can show that you were an independent contractor. And that shifting of the burden to the employer was really sort of the final nail in the coffin. And we had to resolve the case because even, obviously because litigation gets expensive, but the facts were no longer on our side. So while you can hire an independent contractor, you can outsource certain tasks, and financially it can make a lot of sense. There are definitely some pitfalls, and you really need to be careful with how much you're controlling their work. Is this truly someone who's in business for themselves and they're doing this task for a lot of different companies? Or if they're only working for you, an independent contractor who has one client is not off to a great start. It's not to say that that's never allowed, but it's something to keep in mind as a potential pitfall.
So, something kind of relatively new that post-COVID, what a lot of us are seeing is remote work creating new wage and hour challenges for employers. I say all this as a huge advocate of remote work. I work remotely almost 90% of the time. I am working from my house right now. But, it provides tremendous flexibility for employers and employees, but it has created new wage and hour compliance challenges. Not just, I know this webinar is on wage and hour issues today, but it's not just issues we're seeing pop up in the wage and hour realm. We are seeing it in all facets of employment law. One of the biggest misconceptions we see is the belief that remote work somehow changes an employer's wage and hour obligations. It doesn't. You're still responsible for paying employees for all compensable time worked, regardless of where that work occurs. The challenge is that obviously, though, work is no longer confined to the traditional workplace. Working from home, you are always accessible. I know for me personally, I have my workstation set up in my dining room. And so although as an attorney, I am obviously exempt, I can't tell you how many times I find myself sitting in my living room watching TV, hearing my email chime on, a Friday evening, Saturday, whatever, and I go do work. That happens with non-exempt employees too, and they may just go send an email real quick on a Friday. Or again, these things that follow us everywhere. A lot of companies and employees have their work numbers routed to their cell phone. Well, if they're out and about on a Saturday and a client calls about a marketing campaign and they just take the call real quick, and all of a sudden, yeah, they're at the mall, but they're talking to a client and doing work for 20, 30 minutes while walking around the mall, like that's potentially compensable time. And so remote work is kind of creating new wage and hour challenges for employers. You'll also see sometimes where, again, employees kind of log into systems before their shift is to begin, or they'll just continue working. Again, they'll wrap it up and then they'll just be sitting there like, okay, well, I don't have anything else to do. Let me do work. Oh, but I don't want to get in trouble because I'm going to violate the overtime policy. So I'm just going to do the work and not clock in. It'll make next week easier for me. That, it's a lot harder for an employer because they don't have eyes on to see that, an employee's not coming into the office to do that work. But if a manager gets an email from their, direct report Friday at 8 p.m., knowing that that employee clocked out at 5 p.m., that's like, hey, I just wrapped up this report. You can take a look at it on Monday. The manager has knowledge that the employee worked those hours. So, as remote work continues to become a permanent feature of many workplaces, again, a common theme throughout this, employers should ensure that they have clear policies, clear expectations regarding time reporting and after hours work, and making sure that managers are enforcing those policies uniformly.
So yeah, just again, piggybacking off of what Rachel said, right, we could talk about what counts as off the clock work. Before we do that, though, I should also mention, I can't tell you, I'm sure Rachel's in the same boat, how many cases I've seen where it's an off clock claim and the employee can just basically make up whatever they want, right? It is the employer's responsibility under the FLSA to keep time and pay records. If an employee says I worked off the clock and they happen to have, they don't need an email every time, right? We keep talking about the concrete example of here's an email that said, I clocked out at 5, but here's an email at 8 o'clock. You can basically assume that they worked those 3 hours. If they have 5 of those emails over the course of a year and they could say, well, I usually work till 8. I didn't always send an email, but usually I clocked out at 5 and worked till 8. And they have a little bit of evidence they're sprinkled in with a couple emails. That's a the burden then shifts to the employer to disprove that, right? The court, courts have laws that basically say if an employee gives a reasonable, if they sound reasonable, right? If they give a reasonable approximation or explanation for what their hours off clock were, that burden shifts to the employer. So that's where it can get really fuzzy or really really tricky for employers when employees start, I mean, for lack of a better word, just making up hours because they have no incentive not to. So what counts as off the clock work? Basically anything, um, right? Any work done needs to be done on the clock. So as Rachel mentioned, it's a huge issue with technology. Um, in fact, I tell clients that if someone is not an exempt employee, they should not have access to work when they're at home. Now, of course, if they are a remote employee, that's a different set of issues. But if they're not, if they're coming into an office, there's no reason for your non-exempt employees to have an Outlook on their phone, right? All that's doing is asking for trouble. There's no reason for your non-exempt employees to have Slack on their phone or Teams or whatever else you guys are using in the office. All you're doing is asking for them to do work when they're not in the office. So what else counts? There's a ton of cases out there about boot up time on computers. If you give someone access, right, the only way someone can access their time clock is through their computer, and it takes 8 minutes to log in and boot up every morning and load everything and then finally clock in. Well, it's the time that they show up to work that is when the compensable time starts, not when they clock in, right? And there's a string of cases that support that on the employee side. Um, Rachel mentioned this briefly, but clocking out for lunch, but you're still responding for emails. Obviously, the responding to emails is off clock work. Um, we mentioned this also, the deductions for lunch, like auto deductions. I tell clients, or really auto deductions for anything, you shouldn't auto deduct anything. The technology exists, just have someone clock in and out because all you're doing is asking for someone to say, sure, they auto deducted 30 minutes and I would eat for 15 minutes and then I rush back to my computer. Right. There's no reason, um, there's no reason to take that risk. The technology, right? That it made sense when the technology didn't exist, but as much as technology is now can be an issue for employers, employers can use it to their benefit to ensure that they're properly capturing time.
Yeah, like Jason said, kind of talking about the meal and rest break, I had a case once on the plaintiff side where it was security guards and There was an auto deduct of 30 minutes for their lunch breaks, but they would always sit there and say that they would just kind of go to a like break room. But if somebody showed, I think they were security guards. If I remember correctly, I think it was at Fort Sam Houston in San Antonio. They no longer had military service members serving as the gate guards. They had contracted out with a, private employer. And if somebody showed up to try and get on the base, oh, well, yeah, I would just go, check their ID. I don't know how many people here been on a military base in a while, but, they check everybody's IDs. And oh, yeah, I would just, stop eating, get up and go check their ID. And well, that interrupts their break and that's work. And so I had and it was a big collective action for all these security guards. And so, yes, it again can really add up just to kind of piggyback on that. So as Jason had also mentioned kind of about phones and, we think limiting access to work activities on phones and away from the office if employees are actually going in is beneficial because it also creates a treasure trove of electronic evidence that plaintiffs attorneys can use. A lot of times we focus in wage and hour cases just on payroll records and timesheets, but plaintiffs attorneys, they're getting tricky and smart and they are relying on all avenues of electronic evidence to reconstruct an employee's workday. And again, our phones follow us everywhere we go. And so with that said, our phones know where we are at all times. If they're I used to do it on the plaintiff side all the time, although Apple has changed it now, but if an employee would come in and say, "Oh God, I would be at my work location from 8 a.m. until 8 p.m. every single day, and they would only pay me 8 to 5, and I would take an hour for lunch or whatever." I would say, "Okay, let me see your phone." And there is a thing in your iPhone called significant locations, and it's places and tracks where you go a lot. Unfortunately for me, because I work from home, it's home. Or if I get in my car, sometimes my Apple CarPlay will say, "Rachel, do you want to go to Chipotle?" Because unfortunately, I go to Chipotle a lot. And so it's tracking those significant locations. So I used to ask the client or potential client, "Let me see your phone." And I could go and I could see this was, years ago, but at the time, you could actually see on the phone every time that employee had been at that location. So one, it was a great vetting mechanism because I could look at it and say, "Oh yeah, this is your work address. Yep, I see here you were here Friday, 8 to 8, Thursday, 7:30 to 8. Okay, yep, I see that. I see that." Or obviously at the time I would say, shows you're here 9 to 5. I don't really believe your claim." But even though you can't see it on the iPhone right now anymore, Apple took that away. It's still recoverable by a mobile forensic expert, and plaintiffs' attorneys are aware of this. And so they will get those records, they will pull them. Same thing, emails. One of the biggest things we deal with litigation is what we call ESI, and that's just basically electronic discovery. It can be a nightmare, but like every email with timestamps, Teams messages, Slack activity, VPN records, all of that is a record to show the hours the employee worked. And it cuts both ways. It is something that can also help us. We have cases like that all the time where it'll show, somebody will say, "Oh, well, my client was making all these calls from the system off the clock." Okay, we pull the phone records because every phone call is made from the company system. And then here's your time records. They match up perfectly. So, I mean, it cuts both ways, but we are seeing electronic evidence being used more and more and more to the point that, you don't even realize it. We go about our day with our phones and everything, not thinking anything of it. And as we always joke, like Big Brother is tracking everything.
So, what can we do here, right? How do we avoid these issues? Right, there are other payroll practices that create risk, and so I just want to touch on those quickly. I know we're coming up on time, so we have a few more slides. I think Rachel and I are going to try to go through maybe a little more quickly than we have been, but um, obviously bonus and incentive pay. We said before, no good deed goes unpunished. I have a call probably once a week from different clients who want to pay someone more, or they want to give some incentive bonus, and we have to talk through the ramifications for that employee's regular rate. That it's true as well for commissions and shift differentials. All of that gets rolled into a regular rate. So just because someone's paid a commission, that's going to impact their overtime, right? Um, Meal and rest breaks we talked about. The FLSA does not require those. Many states do though. So again, we'll touch on that briefly, I think, in a few slides. Be sure you know where your employee is working, obviously, what state they're in, and what are the state law requirements. The FLSA does say that if you have a rest break, or any sort of break that's 20 minutes or less, roughly speaking, that is compensable time. So don't have your employees clock out to go to the bathroom. Don't have your employees, clock out to go to the break room and get a soda. And don't auto deduct anything, right? Meal break, rest break, anything like that. It's just there's no need, and you're just asking for trouble. Other payroll practices that we see with litigation, or we see, litigating issues, is rounding, right? I don't know. I still have clients that want to. Rounding to me it made sense maybe 20 years ago, but we have the technology there's no need to round. Technology has fixed that need. Um, if it's truly a neutral rounding policy or it favors the employees, then it might be okay, but it is very, very low hanging fruit for plaintiff attorneys. They see a rounding policy, and they'll just file a lawsuit and hope for the best. So I would recommend getting rid of that to the extent you can. Um, Two other potential issues that are state law issues for the most part, but wages are due free and clear of employees. We see this payroll mistake made as well, and employers try to transition it to pay cards. There's a whole set of litigation about different if you're trying to use pay cards, or does an employee, can you charge an employee for a pay card? The answer is no. Wages are owed free and clear. And also the timing of payment, right? Different states have different requirements for how often, pay frequency, how often someone needs to be paid, and the timing of their last check too, right? A lot of states actually require that your last check be handed to you on your last day, even if it's not a payroll day. So those are some practices that might create risk, and hopefully that you guys are avoiding.
So yeah, just kind of quickly get through this. Just the most important thing about payroll policy best practices is again having a strong and defensible payroll practice. And the most important thing I think that we can kind of get across here is making sure that supervisors and managers are properly trained and encouraged to follow the policy. A policy is only important if it's implemented and followed. It can only do so much with that.
So yeah, so like I said, we've been talking about the federal law here. A lot of states have requirements above and beyond the FLSA. For example, California actually does daily overtime, not weekly overtime. New York has something called a shift spread or a spread shift pay, where if your shift is split into non-consecutive hours or it's 10 or more hours, you might actually be entitled to an extra hour of pay. There are different states that have um, different level of damages, right? We talked about the FLSA being a 2x or liquidated damages, right? In Maryland, where I'm sitting, it's 3x. In DC, where I practice a lot, it's actually 4x. So it's important to be aware of what state your employers are in, your employees are in, and then sort of what the requirements of that state are. Because between the federal and the state law, whichever law has more protection for the employee, that's what the employee gets. And I know a lot of clients ask about this. Generally speaking, the law of the state where the work is performed is the law that applies. Plaintiffs will try to challenge that to get to the more favorable law that, sometimes they're successful, but generally speaking, you want to be complying with the law that your employee is working in.
So just to kind of piggyback on that, again, going back to the remote work, like Jason said, it's where the employee's performing the work. And so it may seem like you're trying to micromanage your employees, but if you have remote employees, it is important that you know where they are performing the work. If you have a remote employee who lives in and is based out of Texas, but they've gone to California for a month to work, they could be subject to the protections of California law. So it is very important, like you know where your employees are performing work. And like I said, that is something that is unique with remote work that a lot of employees, oh, well, I just won't tell them. I'll just, go work remotely. I mean, I remember when I first took my remote job many moons ago, got a decade ago, I remember my boss saying, I don't care if you work on the beaches of Fiji, as long as you have a Wi-Fi connection and you're getting your work done. Again, I was an attorney, so I was exempt. It wasn't a big deal. But there are a lot of employers like that. I don't care where you work, just get your work done. I don't care where you work, but I need to know. So that way we know that you are complying with the state laws. Jason kind of talked a little bit, some of the state laws that we tend to see are more employee friendly are California, New York, Illinois, DC, Maryland. New Mexico is similar. They also have the three times damages if there's a wage violation there. Massachusetts has something interesting. It's called blue law restrictions. And so there are certain days of the week that work cannot be performed, like retail sales, I think, are still restricted in Massachusetts on like Columbus Day, Thanksgiving, Christmas. But yeah, so the lesson just for multi-state employers is pretty simple. Like compliance with the federal law doesn't mean compliance with state law. And so you need to be regularly auditing your policies and payroll practices and making sure you're not compliant with just federal law, but also the states where you operate or where your employees may be.
Yeah, and since we're running out of time here, we'll just wrap it up. The goal, obviously, is not to scare everyone on this call. We just want to help you avoid these issues. So, what can you do to avoid these issues going forward, right? As far as classification employees, it's important to review those classifications. Like I said, if you were the CEO or you're going to be exempt. If you were the lowest level hourly employee, no need to review anything, right? It's those people in the middle where are we relying on an exemption? Does it still apply? How have things changed? So reviewing those borderline cases are important. Reviewing your timekeeping policies, making sure you're capturing all time. Like I said, the federal law requires that you keep records of time and pay. So make sure that those policies are in place and well written and being followed. Review your payroll procedures. Um, if your company allows remote work, does it allow it? Great. There should be a policy on what's required and what's not. Does it not allow it? There should be a policy there too. Same goes for overtime. Do you allow non-exempt employees to work overtime? Does there need to be prior approval? It's another thing to, check the policy and train managers on how to implement those policies. If you have independent contractors working for you, make sure they're truly independent contractors, right? It's another easy step to take. And as Rachel just said, check the states that you're in. We're obviously happy to help with that too, to see what other requirements above and beyond the federal law are in place. And one final plug I'll make that I tell all my clients, at least when it comes to wage and hour issues, if you don't have an arbitration program in place, having your employees sign arbitration agreements is a very strong step. It does not a defense towards liability, but as far as that collective action mechanism we're talking about, or a class action mechanism under state law, pulling someone from court where they might have 1,000 people joining them and making them go after their claim as an individual is a really powerful tool for employers. We could have done an entire presentation on arbitration agreements. In fact, I think both of us have at some point. But yeah, a quick plug for arbitration agreements, and that's something obviously that we can help with as well. So with that, I think we have 2 minutes to talk about questions, though of course we could stay on a little bit longer if people need.
Do you
Uh,
want to put up the SHRM code
oh, that's right.
while
Yes.
we answer
Everyone needs the
questions?
SHRM code. Here we go.
Right.
It's like, stop talking, Jason, give them the code they need.
Yeah. What they're
So
here
here's your
for.
code. And yeah, we'll wrap it up there. Rachel or Christine, I don't know if there's any questions we want to touch on.
Yeah, I
I
saw
want to
there's
thank
I
everyone
think
for
there's time for
joining.
one or
Hopefully you found
two.
it helpful.
Yeah, there was one, let's see. If hourly employees are required to come to the office for a daily meeting before going to job sites, do they have to be paid when they arrive at the office, even if they are early for the meeting?
So the answer is the answer is yes, but it's two questions. If they're early for the meeting, right? So let's say that, hey, the meeting's at 9 o'clock, be here at 9. And then we meet for 30 minutes and then we go out to the job site afterwards and someone shows up at 8:45. You can tell them you don't get to clock in until 9 o'clock. On the other hand, you cannot have them do any work until 9 o'clock. So if they are working in their car as they're waiting for the meeting, well, that's actually still work. You have to capture that time because that's time work. So the short answer is yes, if you have them show up for a meeting, that's compensable time. They don't get to just clock in whenever they want, though. They can't just clock in at 7 o'clock and say, I got here early. I wanted to beat traffic. I'm clocking in at 7. I'm going to take a nap in my car for 2 hours. That's not, you don't have to pay them for those 2 hours. But going to the job, showing up at the office before heading to the job site, um, the time at the office is compensable time. So hopefully that answers that question.
That was exactly how I was going to answer it. Let's see. Here's another one. If an employee's exemption is ambiguous, how do you feel about having them track work hours, such as clocking in? I would 100%. I am so risk averse. I would 100% recommend it. It's one of those things, again, like we said, if come to find out they are non-exempt and we have not been tracking their time, they get to provide their best estimate of hours worked, a reasonable estimate of hours worked. And so it's just kind of one of those things that, if it doesn't require the company investing a lot of money in like a, timekeeping system that they otherwise didn't have for some reason, I would recommend tracking hours.
Well,
Just
I also, and maybe I'm harping too much on the word ambiguous. If you don't know what exemption you're relying on, they're probably not exempt. So
exactly.
I would try to shore up the exemption, but I totally agree. There's no downside. There's nothing that says you can't have an employee track hours no matter what they do. Rachel and I are exempt. We track our hours by 6 minute increments. So uh,
Very true.
anyone can track hours. It's nice to have in your back pocket. Another thing to consider in that situation is if you're unsure about an exemption, if that employee is working 70 hours a week, there's a lot of potential exposure there, right? Especially if they're a higher paid employee. If that employee is working 30 hours a week or 35 hours a week, it doesn't really matter because there's no exposure, right? So practically speaking, you want to take a look at sort of what do we want to do with this exemption, or this exempt classification? Do we want to rely on it and roll the dice? Is this person only working 40 hours anyway, so it doesn't really matter? So yeah, hopefully that answers your question there.
Right. Any other questions? If any, we're going to provide you with our contact information. So if you guys have follow-up questions, feel free to reach out to us. We will do our best to answer the questions. Anything else, Jason?
No, I think that's it. I don't know if Christine has to say anything at the end
We're just-
or if we just wrap up, but
yeah.
I
Thank
guess
you
so.
guys for joining us.
Yeah.
Thank you all so much. Thank you, Jason and Rachel, for this great presentation.
Okay. Well, thanks for joining us. Take care, everyone.
Bye, everyone. Thank you.